constitute an effective remedy in this matter, having regard to the dicta I referred to this morning. And the reason the common law is insufficient is because there's no recognition in the common law for a claim based on the loss of a life in these circumstances or the breaches of constitutional rights such as have occurred in these circumstances. That is the simple reason why the common law damages don't go far enough.
In fact, the common law is quite remarkable on the issue. Mere death alone is not a cause of action.
It's not a cause of action, and in our written submissions we set out how that has come to be in our law, and through the influence of our through the influence of Roman Dutch and English law. But that is the state of the law as it is right now. That is the current position of our common law.
Yeah, that excursion is helpful. I saw it. Thank you for it. But it of course, accentuates the question. When the common law was formulated, something like a right of access to health care was nowhere near in the horizon. Cruel and inhuman treatment, and it was slavery then. And in fact, the principles, by and large, don't they? The more money you have, the more you get rewarded. So the emphasis on patrimonial damages.
That's also something we allude to in our.
Yes, indeed you do. You go ahead
I'm not going to go through all of that because it's set out in the written submissions.
Set out fully, very admirably. Thank you for that. No, you can go ahead. You don't have to.
Thank you, Justice. But just in relation to the last point you made, I draw your attention to our reference to Carmichael and the extract from Carmichael that we included in our written submissions. And even though that extract was dealing with the question of development of the common law, we submit that it is equally relevant to remedy. And that is that given where we come from and given the Constitution and the notion and society's notions of what justice demands, what Carmichael says is that these notions of what justice demands might well have to be replaced or supplemented and enriched by the appropriate norms of the objective value system embodied in the Constitution. And that's simply just to address your last comment about where we stand in the common law. Yeah. What we do know is that standalone constitutional damages have been awarded in at least two cases. There are two precedents, and that is Kate and Modoclip. And in the case of Kate, the facts I think are quite well known, and it was in relation to the endemic failure of the Eastern Cape government to provide social grants to people who had applied for it and the inordinate delays in the system. And in that case, the court considered the award of constitutional damages. And they did so even though they accepted that Mrs. Kate was not entitled to her claim for interest on the amount that had been in relation to the delay of the social grant. They awarded that the social grant should be paid from a certain date onwards. They recognized that the interest as claimed by Mrs. Kate was not available to her in the law because the debt had not yet accrued. But they chose to award the damages partly on the basis of the systemic and sustained failure of the government to award social grants in that province. And what the court said is the following, and this was the judgment of His Lordship, Mr. Justice Nugent. In my view, the breach in the present case warrants being vindicated directly for two reasons in particular. First, I see no reason why a direct breach of a substantive constitutional right, as opposed to merely a deviation from a constitutionally normative standard, should be remedied indirectly. Secondly, the endemic breach of the rights that are now in issue justifies, indeed it calls out for, the clear assertion of their independent existence. Although the amount of constitutional damages to be awarded was debated in that matter between counsel and the bench, on the basis that Mrs. Kate had not suffered direct financial loss, what the court said, and I quote, "It has not been shown that Kate suffered direct financial loss, and it is most unlikely that she did, for the grant was destined to be consumed and not invested, but the loss was just as real. And in the absence of an empirical measure, the court awarded the amount equivalent to the interest to which Mrs. Kate would not otherwise be entitled." And importantly, in this case, the court made it clear. But while the question as to whether the claimant has sufficient remedies outside of constitutional damages is relevant, while that is relevant to the assessment of what is just and equitable, it is not on its own decisive. And it's set out very in unambiguous language in the judgment. And I'd like to refer, Justice, to the passage, and where the SCA said the following: "No doubt the infusion of constitutional normative values into delictual principles itself plays a role in protecting constitutional rights, albeit indirectly. And no doubt delictual principles are capable of being extended to encompass state liability for the breach of constitutional obligations. But the relief that is permitted by Section 38 of the Constitution is not a remedy of last resort to be looked to only when there is no alternative and indirect means of asserting and vindicating constitutional rights. While that possibility is a consideration to be borne in mind in determining whether to grant or withhold a direct Section 38 remedy, it is by no means decisive, for there will be cases in which the direct assertion and vindication of constitutional rights are required. And that is precisely what the claimants are seeking in this case, the direct assertion of the Section 38 remedy in relation to the rights that have been violated. Justice have referred to Modiclip, and in a similar vein, the court awarded constitutional damages as a result of unlawful occupation of the farm, Modiclip Farm, and in that case too...
And more importantly, the omission of the state to take steps to restore vacatio possessio to the owner. The invasion was in front of the police were alerted to it, and the police failed to fulfill their obligations, to give assistance to, in the face of an unlawful conduct. So that was quite an important consideration indeed.
That is so.
State omission.
State omission. And although it was difficult for the court, well, it wasn't difficult, but although the court observed that there isn't an empirical measure, again, for the calculation of constitutional damages, they used the mechanism under the Expropriation Act as a means of determining an amount of compensation. It wasn't based on any pure patrimonial loss and calculation as it normally is. So the key principles that we see that emerge from these cases is that constitutional damages may be awarded for violation of rights as a self-standing remedy in appropriate cases. 2, while the question of whether the claimant for constitutional damages has sufficient remedies outside of constitutional damages is relevant, it's not decisive. Section 38 is not a remedy of last resort. And the nature of the breach, example in Kate, the endemic nature of the breach of the right, and in Modiclip, as you pointed out, Justice, may call for the independent assertion of the right. We've had regard to comparative law, and we've included that in our written submissions. And we think that it's in relation to Canada, New Zealand, and Trinidad and Tobago, We consider these to be helpful in guiding us in understanding how constitutional damages have been awarded in other jurisdictions. The Canadian case is particularly important because of the similarity between the Charter and our Constitution. And in Vancouver versus Ward, the facts of the case were, it was a case of a would-be pie thrower who was unlawfully arrested. And so that was the basis of the claim and the breach of rights in relation to the unlawful arrest. The Canadian Supreme Court, that in order to award damages, there's certain factors, hurdles that the plaintiff has to cross. And the first is that a constitutional right has been breached. The second is that damages are just an appropriate remedy in that they fulfill the functions of compensation, vindication of the right, and or deterrence of future breaches. If it's established, if the first two are established, then the state carries the burden of adducing countervailing facts that defeat some of the functional purposes of the damages. In the absence of persuasive countervailing evidence by the state, the court will proceed to determine quantum. With regard to the purpose of constitutional damages, the Canadian Supreme Court said the following: damages may be awarded to compensate the claimant for his loss, to vindicate the right, or to deter violations, future violations of the right. These objects, the presence and force of which vary from case to case, determine not only whether damages are appropriate, but also the amount of damages awarded. In other words, we are submitting that not only are the facts of this case relevant to the necessity of constitutional damages as an available, as an effective remedy, but also it's relevant to the quantum of damages. And we base our reasoning on the helpful guidance of this judgment. Justice, the New Zealand case is set out in our written submissions. I'd like to emphasize the one passage which we've referred to, because what is interesting about it is that it recognizes a dual purpose of the Bill of Rights remedies, and the recognition that when there are breaches of human rights, there are two victims: the individual and the immediate victim, and that victim's interests, but also society as a whole becomes a victim too. And I think this, and again, in the circumstances of this case, is relevant to the award of damages as well as the quantum that we will see.
And for good reason, isn't it? If constitutional breaches abound and they go unpunished, it's a matter of time before all of us will be engulfed with the illegality. So it's also a measure of public self-interest. It's a little like the state having always the right to charge a rapist, even if they make common cause with a victim. It's a broader principle, the same principle enunciated there. It's a principle of public good and an invasion, therefore, of public good if you have endemic illegality and unlawfulness that is unchecked. So you cannot wish away or agree not to be prosecuted, for instance. So it's pretty much the same principle. Aside from that consideration, it's important to protect the constitutional arrangements we have. And when they are breached, there should be responses. What redress ought to be then becomes the second inquiry. So I understand the submission.
Thank you, Justice. In those circumstances, we submit that the claimants should be awarded constitutional damages on the following bases. The facts of the case are so shameful that it's difficult to imagine circumstances more deserving of an award of constitutional damages. The ostensible reasons for the decision to terminate the contract have been shown to be false. The wanton violation of numerous rights, in our view, is indisputable. I had initially said it's undisputed, but I take that back. Despite all the attempts by the families to change the course of events, their pleas went unheard. Even in death, the mental health care users had no dignity. The families were further traumatized by having to visit mortuaries, identify their relatives, state of decomposition in some cases, and the record is littered with examples, some of which I've referred to in my address to you. The officials or health professionals fail to be moved by their own ethical code, and Professor Dye has provided cogent evidence as to what those obligations are. Professor Krobler addressed the disconnect between bureaucratic decisions taken despite forewarnings by clinicians responsible for the care of mental health care users. And in the opinion of Professor Dye, she likened the entire endeavor to a cruel experiment. It was possible, she says, because the subjects were vulnerable and disabled. She likened the project to patients being herded and taken into, in her words, taken into concentration camps as described by families. For me, she says, it is a distressing reminder of Hitler's Nazi war atrocities, where the vulnerable were considered to be subhuman, of decreased intelligence, of no moral status, and lacking human dignity and therefore exploitable. The evidence of Mistrotter, in turn, also speaks to the pain and trauma that goes beyond anything our courts have ever had to deal with. That is the reality we face. In our written submissions, we dealt with the evidence of Mistrotter. I didn't revert to it here because we've settled on the issue of common law damages, but I wish to stress, Justice, that the reference to those findings by Ms. Trotter are not only relevant to common law damages, but to constitutional damages as well. The state officials blithely ignored their constitutional duties under Section 195. We've had some discussion, Justice, on this in Section 195 and the I don't know response. In the beginning of our written submissions, we set out in some detail all of those responses by the officials in which they claimed they didn't know. And we submit that this is a stunning response in the true sense of the word. It stuns one. And it's an echo of past atrocities in human history where the same claim was made. Despite the disclaimers, and despite saying that they didn't know, there are officials who testified that accepted the magnitude of the atrocity.
And right there, surely the apologies from senior state or public office bearers must carry some weight to assuage or to mitigate the extent of the hurt and the amount of equitable redress, isn't it? The apologies are not without consequence. I'm talking less about untrustworthy witnesses, but more about those who did not perpetrate themselves, but who sought to apologize on behalf of the state as a whole. That must carry some weight, surely.
I think that it's relevant. I think it carries some weight. I think apologies are important in these particular proceedings. It's part of the type of redress that was envisaged. And hearing an explanation was part of the redress that was envisaged. I would agree with you to that extent, Justice. Of course, some apologies were more sincere than others. And even in those sincere apologies, it doesn't take away from the breach of the rights and the violations that took place. That is what I have to say about it.
Yeah, but it does mitigate, the hurt. What doesn't mitigate the hurt, and you make the point, is untruthful explanations of what happened, or the absence of explanation of why it happened. That exacerbates, no doubt. But as you weigh up and exercise the discretion, as an adjudicator, you say, there were apologies.
I think they ought to be taken into account, but at the same time, Justice, I stand by my submissions that it doesn't take away from the breach. And in fact, that we stand here today without answers.
And that the seniors themselves could not unfathom this irrational decision. None of them could say to us now, a year later, we know what happened.
That is so.
There was an apology, but nobody was really saying, you know what, Eureka, I found it. This is what happened. They seem to be as ignorant as we are.
And leave us to speculate what the possible reasons could be. And we hope that more answers will come. We hope that this won't be the end, that answers will continue to come even at the close of these, after the close of these proceedings.
Is it relevant that the state agreed to be a party to the arbitration? Is that a relevant consideration in deciding the extent of compensation as part of equitable redress?
Just as our courts, for example, in Njongi, have spoken about the duty of the state where litigation occurs, where there's litigation on the basis of constitutional rights, to participate in a certain manner. I think that the participation in the arbitration process is consonant with that duty. I wouldn't want to take it further than that.
Yes, of course you can compare the response of the state here to the response of the state in Marikana.
Well, if that's our yardstick.
Here we're dealing with a contrite and a remorseful state, at least from the high end of the province leadership. And there you dealt with persistent denial of any liability of any kind whatsoever.
My submission
so there is a difference. I'm saying a state could have the obligation to behave in a particular way, but we know as a matter of fact that quite often there's contestation that leads to a lot of grief and hum and cost and sometimes failure to prove a claim. So I'm just asking, is the attitude of the state here a relevant factor in weighing up what is just and equitable?
As I hear the question, and I think I am not misrepresenting the families when I say that there's an appreciation for that attitude of the state, the cooperation. But it did come after a very long, hard, gruesome process. And I think that the standard and the measure is rather what the courts have said is the duty of the state in litigation of such nature, rather than past bad experience.
Yes.
That now requires me to turn to quantum. And what we would like to submit in this regard is that there's, as we've said in our submissions, there's no manual for calculating the monetary value of a life, nor of the price tag of the grief and the trauma that families have endured. There's no way we could put a price tag on this. But the families have chosen to refrain from what often happens in cases of general damages. And that is to refrain from presenting a thumbsuck figure and to place some evidence before the arbitrator that gives some guidance as to the basis for the quantum that we seek. And to do that, we provided the actuarial report of Mr. Gregory Whitaker. And what that report does is it provides evidence of the money that the government would have spent on the deceased if the marathon project had not taken place, or as Mr. Whitaker refers to it, the money that they saved. And he presented different scenarios, and I'll turn to that in a second. But I want to stress that our reference to this is not on the basis of some sort of enrichment claim. It's simply a way to assist the arbitrator to understand the numbers and what would be a reasonable award of compensation. Mr. Whittaker provided 3 scenarios, and these are set out on page 91 of our heads. And you'll see from the scenarios there were variables that were taken into account, including the life expectancy and the net discount rate, so the present value, in other words, of the money to be awarded. And the families have chosen to follow Mr. Whittaker's recommendation, which is a middle-of-the-road recommendation, which places us in Table 2, the second table, the middle-of-the-road loading of 120%, which is 1.5 million. That is how the amount of 1.5 million was determined for the basis of the statement of claim.
I'm grateful that there was an attempt to compute and quantify the claim. And I struggle still a lot with the usefulness of the quantification in this particular context. What is the premise? The premise is, had mental health care users lived, this is what the state would have spent on them.
If these mental health care users had survived, this is what would have been spent on them. Yes. If they, not if they survived, if there was no marathon project.
If there's no marathon project and therefore they continued to remain at Life Esidimeni at the cost that they were at the time, and you give them an actuarial value, you're really saying, if you had not killed them, this is what it would have cost you. So the basis of the calculation is very, very challenging. I can't bring my arms around it. And it creates another tension. General damages, unlike special damages, are not susceptible to exact calculation. And the courts have over and over again, in fact, they defy calculation. That is why there's so much discretion in the adjudicator, in the trial of fact and law. So this is quite a mixed approach.
Yes, Justice, I see your difficulty. Perhaps if I could try to explain it in this way. There is no exact science. This figure doesn't bind the arbitrator. It is an attempt to provide an evidence-based figure and a mechanism in a similar way to which, in Kate, for example, the interest was used as the placeholder. There was no suggestion that that was a calculation of damages in a way that...
that's hankering a little to the past. It's trying to put monetary value on human beings. There are moments when that is valuable. But think of a proposition for a moment. If an actuary and a garden worker were to die in exactly the same accident, let's add a third person who was unemployed, and there's a claim. You know that the actuary is probably going to get 1,000 times more than the garden worker. because the formula is to place the claimant in exactly the same position she would have been but for the derelict. That is the law, common law as it currently stands. So you place the gardener in the same position as he was in poverty. And as for the unemployed person, on the common law formula, you give them zilch, nothing.
Or for a mentally ill person.
Yes, or mentally ill person, because they had no source of income.
Yes.
So when I look at actuarial calculations, it's almost an invitation to go and weigh up
Yes.
people in terms of money. And I'm raising something quite fundamental about how
that.
law has approached computation of damages. It's a class-driven kind of formula. You're an actuary, I gave you 20 million, you're a gardener, sorry, I give you only as much as you otherwise what you would have had, and you had nothing, I give you nothing. So at law school, we always take those formulae for granted, and we take them. And as you go along, you start asking difficult questions, which I'm asking now.
Justice, there's much to be said for the invidiousness of the approach that has been taken and the precedent that binds us. But that is not what we are proposing. The figure here is not intended to represent the value of the life. It's to take into account a series of circumstances, including, and importantly, the breach of rights. And the breach of rights, under the facts of this matter, the wanton violation and the ongoing disregard of the attempts by the families to save the situation.
You see, Advocate Hasim, some breaches like in Murder Club, denial of the use and enjoyment of a farm, clear ready-made value, and you value an animate object and you say, get an equivalent of the market value of your farm, and you order the state to pay it. Fair, equitable.
Mm-hmm.
It's a right of access to property, and has been violated, it is easier. When you kill somebody in horrible circumstances, and they have nothing, in circumstances that violate fundamental values of the Constitution, what is the just and equitable response of the law to that invasion? Where damages can be specified in specific circumstances, well and good. Funeral expenses and whatever else. But where the violation happens in circumstances where people have nothing, is the proper response of the law nothing?
Justice would submit that the difficulty, because that's what we face, is the difficulty in being able to price what has happened, to price the loss and the violations, doesn't follow from that no award should be made. That surely is not the logical conclusion. If anything, one should err on the side of making an award rather than avoiding the award.
Yes. I agree with you. It was a long discussion, but it also exposes some of the thinking. Prima facie, as you know, as a lawyer at this stage, wrestling with a number of legal notions, past and present, and how just and equitable they are. For the actuary to get 50 million and the unemployed person to get nothing in exactly the same set of violations. So that is a money, it's a patrimony-driven kind of compensation system and whether the Constitution countenances it as the only system you could use. Coming back here, and I hear what you're saying, I'm struggling to find, it's interesting, but to find guidance out of the numbers in weighing lives of people.
Of course, Justice,
Had you lived, I would have paid so much for you, therefore. That's the extent of my damages. Can you imagine a parent saying that about it? Own child or son? Had you lived, I would have paid so much, you are gone, and therefore I lost that much.
Justice, but I don't want you, please, to misunderstand what we're saying, because that isn't the basis. It's as I've said, but also to show the reasonableness of it, particularly in respect of the impact on the public purse. And to, there may well be the arguments that will be made, I haven't seen them yet, that this will have an undue impact on the public purse.
I understand the point, but okay, let me hear further submissions on that. At this stage, prima facie, I'm unpersuaded that this is useful, and it doesn't detract from very excellent heads that I've had before me. But I'm very reluctant to, in relation to general damages arising from constitutional breaches, in other words, constitutional damages of this genre, this particular genre. I've shown you what happens in Model Club. It's uncomplicated, it's much, much clearer. And there you're calculating value of inanimate objects like property, easy. When you start weighing up human beings, in the context of general damages, it becomes quite a challenge. And traditionally, there wasn't. Oh, he's got more money, she must get more. Oh, she's got little money, she must get nothing. But that is hardly, certainly my jurisprudential
Well, one
work.
could argue the other way around. He's got little money, therefore we should get more.
Yes.
But I hear your point.
Yes.
And Justice, on the question of the public purse and liability, we submit that has the issue of limitless liability is not relevant to this award.
No, I don't think so at all, if you think for a moment. We'll debate that with Mr. Witame later. We have unaccounted or wasteful expenditure of 6.8 billion in the health department alone. So when you think about people, also think about all of these, that's evidence before me. The same department is able to rack up 6.8 billion and 1.6 of it being suspect, where they've been referred to the police.
That is for precisely our submission. That
it's part of the context in which I would think about
indeed
about the money and what would be just and proper for people who are otherwise very, very placed in needy circumstances. Very well.
If I may move from here to the other equitable redress.
Yes.
And Justice, in the interest of time, it is set out in our heads of argument. As I said, it's not controversial. I think it's not controversial. It's relevant. It's relevant to the future, into how to ensure that this doesn't happen again.
Yes.
And so, in that regard, we asked for certain steps to be taken and information to be made available. That information, which has in fact already been offered by some of the officials, and we would seek an award to be made by the arbitrator to reflect those paragraphs from 353 to 357.
And it's a form of structural interdict. How would that be policed? How would we know that these steps are being complied with?
Justice, we didn't include any supervisory element. We anticipated that Justice would want to be shot of this once the awarders handed down. We would hope that in the light of the cooperation that has been to some extent at play.
You could put the ombud, the referee, you could put the ombud to be the supervisory body.
I'm indebted justice. I'll take that. And I'd like to add that then, that the ombud could be the independent arbiter as to the provision of the information and the compliance with the recovery plans and so on.
He's asked for this. It is being done, and he can scream and shout. This is done very ably, and say ordinarily a supervisory order would go back to court. A SASA case is an example. It's an order which was made when I was still on the court, and the court is still trying to supervise it up to this day. So supervisory orders have got that lag. They live around for long. So somebody like the ombud, typically that would be within, yeah, very well.
Justice,
I don't know whether the point will be argued, but I'm raising it now, and some of your colleagues may touch it as you sit down, is the arbitration agreement makes provision for compensation individually or in groups. I haven't heard, the state doesn't argue that, nobody argued it. Ordinarily, damages are individualized. And damages could be granted collectively. And the agreement says so. You may do that. Is there any reason why I shouldn't do that? Is there any impediment in law why I couldn't do that?
Justice, we see no impediment. And again, it goes back to the terms of reference and what jurisdiction has been granted to the arbitration, to the arbitrator to make such a decision. And it's partly, and a relevant factor is practicalities. I'm instructed that there is a process that will follow afterwards for advising the families, but that's not the concern of the arbitration.
Yes, and the last thing, just before you sit, and I'm going to urge you to sit, the last thing is the submission of part of the awarded money being placed in a fund that would do good in relation to mental health care users. Are you still going to get there?
Justice, that
is quite intriguing, very interesting. Again, I'm just thinking, how would that fund be? How would the hygiene of that fund be policed?
I think that what would be useful is, in the same way as we need to specify the relief in respect of the counselling, we could, and it would assist us to work with the department on how to formulate that, because we are not privy to the mechanisms within the department of such funding and donations and how they are managed.
Of course, you have to have that debate with your colleagues. Of course, the money is truly an intriguing idea, a very selfless idea. Of course, the money could be placed in a fund jointly managed by civil society and representatives of the department. And therefore, there would be near automatic joint ownership of the goodness that might come out of it, but partially fund the ombud in the work that the ombud might have to do for mental health care users in particular, and so on. So I found that there was no proper ring fencing of what effectively would be a donation from families of the mental health care users. I mean, donation from the claimants.
Donations from the claimants for the for allocation to the mental health care budget. So the idea was that the funds would be used for the survivors and others in similar position. But I hear you, Justice, and there are different ways to skin that cat. And there are different mechanisms in which we could set up a joint fund or just have transparency and accountability from the department to show that the money is being spent for the benefit of the mental health care users in the Gauteng province.
Yeah. If it sits in a ring-fenced fund of sorts, it will be quite helpful. Also, you will keep the memory alive of this horrible tragedy. But if it's just poured into the big pot that sometimes has unauthorized expenditures running into big numbers, then the intended impact might just dissipate.
Hence the qualification that it needs to be ring-fenced and that there needs to be a proper, transparent accounting mechanism for the expenditure of those funds.
Yeah, but I leave it to the parties. I mean, by the time we finish tomorrow on whether ring-fenced means within state funds or ring-fenced means in a fund outside of the normal budgetary processes of state. Very well. Any further submissions?
Justice, subject to your
costs
instructions, I do have to come to costs, but there's one aspect of the submissions that I haven't gotten to, and that is the claimants and their family members, and who it is that we, in respect of which victims and which deceased we're claiming.
You're taking me to the annexure, are you?
Well, it's annexure A. I had intended, Justice, to, in the plea to you, in your deliberations in relation to the award, to hold in mind the faces of the deceased. And it was in that regard that I intended to refer you to who they are, and with one or two facts about them, in order for you to have a fuller picture of the people and the lives that were lost and the place they held in the family unit. I would wish to do so, but I understand the time constraints, and I'm in your hands.
How would you want to do that? I've looked at annexure, is it A or 1? Most useful. And absent an attack on it, I take it as gospel.
We're not aware of any dispute in relation to annexure A. But what annexure A doesn't do, Justice, is give you the sense of who the people were, their names, and then there are references to the record where you can find the facts in relation to each of those deceased.
Yes, I thought it was valuable, but you say you want to humanize the list more. You want to have a roll call of sorts and place flesh and blood to every claimant. Is that it?
A roll
to the
call,
deceased or to the
and to give and to provide some sense of who they were as members of a family.
Yes, I think it's going to take quite a lot of time, and it's a lot of time that we must find in your closing remarks, in the reply. And the reason for that, we need to get to grips with the real disputes between the parties. And I don't think this is disputed. And given the verification process, we should come back to it. Is it okay? Unless you see some prejudice, I think you should come back to it.
I see no prejudice.
Closing remarks.
I'm indebted to your Justice.
We will then create the time tomorrow to do that.
We will deal with it in my reply. That leaves costs. my instructions are that the costs have been borne by Section 27. They claim no costs in relation to the services of Section 27 or the disbursements. But there is a claim for costs for one counsel. And that is necessary because it's part of the agreement that Section 27 has with legal aid that is part funding the litigation. So costs to include the costs of one counsel.
And exclude attorney's costs, would it?
And it would exclude attorney's costs.
And exclude the cost of one other counsel.
We don't know which one yet, but yes.
Those are submissions on costs, okay?
Those are my submissions on costs, and those are my submissions on costs. I just been handed something that I should have alerted Justice to earlier, and that was there was an interlocutory application for the provision of post-mortem reports that was made earlier in these proceedings. The application speaks for itself. We haven't received any notice of opposition to it. It's simply for the arbitrator to consider in the award the provision of those post-mortem reports to the families. The SAPS has agreed to provide it to the arbitrator, and as for provision to the families, they leave it in the hands of the arbitrator, and we request the arbitrator.
But were there costs granted in the interlocutory application?
Costs? I'm not aware of that.
I don't understand the submission then. Just help me understand.
Sorry, this is not in relation to costs at all. This is simply the interlocutory application that was made.
Yes.
That I was remiss in mentioning at the outset of the proceedings. It would have been better to clear it out before I began my address on relief. But I didn't want to let it go because we do require an award from you for the release of the post-mortem reports.
Okay, very well.
Those are my submissions, Justice.
Thank you. Advocate Lila Krauser,
May it please you, Justice.
Let's look at the time. It's 4:05. You're going to run for an hour and we adjourn, is that right? Then you can continue tomorrow.
Yes. Justice, I'm very concerned that we won't finish tomorrow, or that we'll sit late into the night. But I'm of course in your
I can sit late into the night today. I can't tomorrow.
Yes.
For reasons I've privately disclosed to.
Yes. I was wondering whether we shouldn't at least finish the claimants today.
Okay.
In order not to sit late tomorrow, because I'm concerned insofar as we received the heads of argument of the state very late last night, that we haven't given them proper thought, and that our right to reply might be lengthier than we anticipate. So if you will allow us, I would rather sit late today. And
sure. Let's do. Let's sit late. I'm quite happy. After an hour and a half, we'll take comfort break and then continue.
Thank you, Justice.
And Advocate Grunewald, are you up to it?
Yes, Justice.
Because you'll be next after this.
Indeed, sir, Justice.
So if there's any prejudice, it'll cover you too.
No.
And then we'll hear Advocate Dutamo then tomorrow morning as originally planned. And then have a reply then from the claimants also tomorrow. And as I gather, evidence leaders will not be making any legal submissions.
None, Justice Mr. Yeah. Although we have prepared something in writing, but we're not going to speak on it.
Yes, I think that's proper. Proceed, Counsellor.
Thank you, Justice. Justice, just to put it in perspective, our list of clients have now reached 68 people, and we will make sure that that list reaches you before the end of today.
Yes.
We've prepared just this fairly substantial heads of argument akin to written argument, so I'm not going to read everything or refer to everything. If I might just page through it with you, I would be glad to do so.
Yes,
and I will start.
It will be easier that way. Let me. I've just closed the section 27.1. Let me just open up yours. I've got it. It's open before me. Thank you.
Thank you, Justice. I will start at paragraph 4 of my heads of argument, just to reiterate that, Justice,
Will you just repeat that number again? It's now
68.
68. Thank you.
That you've mandated us to act for the survivors and their families in terms of the entitlement in paragraph 2.3 of the terms of reference. And we refer throughout to these people as survivors and their families. But we have been unable to make contact with all the survivors, despite our best efforts, and therefore our list now stands at 68, and we will make sure that that new list reach you today. Can I just work in, at this stage already, after we filed our heads of argument, the state has objected to our prayer that the missing or the unrepresented healthcare users be included in any argument of us. And I just want to give just some background to this, if I may. And I think it was raised in this, the statement of opposition by the state which we received after we filed our heads of argument. Now, there are two categories that are unrepresented if we don't represent them. On the one side, it's the missing mental health care users, and nobody can find them. And the other side, it's those mental health care users that's non-compos mentis and that we could not take instructions from, who has no family members. So those are the two groups that we say we entitled to make representations for. And in doing so, I want to refer you to section 15.2 of the Mental Health Care Act, which states that a mental care user is entitled to legal aid South Africa in any conduct or institutions of legal proceedings in terms of this act. And I would submit that the arbitration could fall into that category.
Of legal proceedings.
Of legal proceedings,
Yeah.
yes. And these proceedings, with respect, as already pointed out, are with the consent of the department. And in terms of our manual and our act,
Which department now?
the Department of Health is
Yes.
part of the
Arbitration. Yes.
of the arbitration. But in terms of our act, the Legal Aid South African Act and the manual, we act for people that's indigent and vulnerable, and these groups, by definition, fall within that. And in terms of our manual further, when indigent and vulnerable people is at risk of being abused or unfairly discriminated or exploited, we are obliged to act for them. Now, if we then go to the terms of reference, it's our submission that these people fall within the entitlement of the criteria in 2.3, and that the terms of reference mandates the arbitrator to determine redress for affected persons in the Marathon Project. They also fall into that category. They are missing in terms of LR 163. We have that list, except for one of our clients that's not on the list. And the states have accepted liability for them. We would therefore submit that we're entitled to represent them, even though we don't have specific instructions. But it goes further than that. And the reason that they should be given redress is our constitutional principle, that a court will not only deal in effective relief with the parties before it, but it will also deal with people similarly situated. Because of this, it's our respectful submission that there's a wider public dimension, as stated in our authority, and the bell tolls for everyone, as stated in the National Coalition for Gay and Lesbian Equality. The citation there is 2009-1 SA 390 Constitutional Court. This, in our submission, requires a consideration of the interest of all those who might be affected and not merely the parties before the arbitration. And this was also set out in the matter of S versus Tunzi, 2010, in brackets 10, Butterworth's Constitutional Law Reports, 983. And in this case, Justice Moseneke, you were part of the bench, and I was arguing the matter. The Constitutional Court made great effort to deal with people that were similarly situated in that matter. And if I could then just perhaps quote, lastly, Justice Hurrams in the Modderfontein matter in the SCA, he said, courts should not be overawed by practical problems. They should attempt to synchronize the real world with the ideal construct of a constitutional world, and they have a duty to mold an order that will provide effective relief for those affected by the constitutional breach.
Can we pause there for a moment? It's a matter that has been engaging me quite a bit. What would be the reach of the award in relation to the two categories you have addressed me on, as well as the 68 mental health care users on your list? There were approximately, 1,400 and something people.
1170, I think it is.
1170, who, 1170. What would be the reach of this award in relation to?
To those people. Justice,
how do you make the bell toll for everybody?
We've submitted, and I will submit this when we argue the remedies, but we have submitted that the best place to suit these mental health care users is by making an allocation which is paid into the Guardians Fund. And the Guardians Fund has, it's these days in terms of the Estates Act 66 of 1965, but it hasn't always been. But it's always been in terms of the provincial legislation since before time, it seems to me, to deal with people, children, and they still refer to the term lunatic and missing persons. So our mental care health users would fall within those terms, and it would, the money would be available for them. That money would be available until they die, and thereafter, if nobody claims it, or if it lies there for 30 years, it will fall back to the state, which I submit is the best solution that we could think up in the circumstances.
But during the order, do we know the names of the balance of potential claimants.
Yes, Justice, it's attached to the list that the state provided. So we
Yes.
have that.
Yes. So, if we know who they are, we could very well make awards that would accrue to their benefit.
Absolutely, Justice.
That's the submission you made.
That is our submission. And of course,
subject to means to access the money
yes.
out of the Guardian's Fund.
The means to access that would be if they're no longer in a state where they're not compos mentis, or when a family member on their behalf make representations to the master. And that's the master's role in the Guardian Fund, I submit.
Yeah, and the beauty of that arrangement would be that they won't be obliged to start their own arbitrations
No.
later, nor would the state want to be litigating forever on this matter.
Absolutely, Justice. And it will also make provision for family members that belatedly hear about this, the whole incident. We, of course, not catering for those family members because just logically we don't imagine that they have suffered any damages if they're not part of the arbitration hearing.
Well, an order of that type could be useful also for claimants in respect of mental health care users who have died but are not on Section 27's list currently. I'm just saying the formula is interesting because it could then catch him in that situation.
I think, Justice, the family members, those who have died and that we know that have died, their claims might not be in existence anymore. But those that have survived, their claims are still in existence. Their families have not played a role, so I don't know whether we would want the family members has not been part of these proceedings, knowing how widely it was publicized, that they would have a claim at this stage. So I'm not so sure that that is the way that one should go, Justice.
Why would it be okay to go that route with survivors?
Because the survivors have suffered, in my submission, and we will deal with that in our remedies. But their suffering is there for everybody to see. But their families, if they are non-existent families, might not have suffered. That's the gist of our submission.
Okay, I follow that. Thank you.
Thank you. Justice, we've also provided a timeline. We're not going to refer much to it at this stage because we are not going to deal much with the facts of the matter. If I can take you to paragraph 6 just to indicate the structure of our heads of argument. We deal firstly with the purpose of the arbitration proceedings. Then we deal with the harm-causing conduct. And the harm-causing conduct we've put into 3 categories. Firstly, the state's obligation towards mental health care users, and then the disgraceful disregard of these obligations by the Gauteng Department of Health. And then lastly, the effect this had on surviving mental health care users and the families, and then not really as an afterthought, but we also deal with the losses of people who are not healthcare users or families. We just put that in there, Justice, as we will say, to show that there were really unintended consequences and no plan. We will deal with wrongfulness, and then we will deal with the relief sought. If I could just then go back, in respect of the disregard, we will show 7 failures or headings under which we deal with the disregard. Now, the purpose of the proceedings, Justice, is in our heads of argument, and I don't intend to deal with that. The harm-causing event is at paragraph 13, we just say it can successfully be described as the Gauteng Departments of Health irresponsible and rushed continuation of a irrational marathon project to move 1,711 mental health care users, despite being told in no uncertain terms of the consequences, and in so doing causing the death of at least 143. And we say that the mental health care users and causing severe suffering to others and their families. And this conduct was either reckless or grossly negligent. Now, if I can then start off at paragraph 15 with the state's obligations to these mental health care users, we state that South Africa is bound by the international obligations, constitutional principles, legislation, and policy. In paragraph 16, we deal with the Universal Declaration of Human Rights. In paragraph 17, we deal with the African Charter on Human Rights, the Benjol Charter. In paragraph 18, we'll deal with the Convention on the Rights of Persons with Disability.
Yes, this summation of international standards is very helpful, and thank you very much for that.
Thank you, Justice. In paragraph 19, we deal with the 1991 UN Principles of the Protection of Persons with Mental Illness and for the Promotion of Mental Health Care. In paragraph, Justice, we're skipping a few pages. Paragraph 20, we deal with the compliance of our international obligations as it also stands in our Constitution. And we make the submission in paragraph 20, Justice, that the NGOs should be regarded as organs of state vis-à-vis the mental health care users. And in this regard, we refer to the all-pay matter. If I could perhaps just very briefly, Justice, I think you were still part of.
Yes.
Yes. It says in paragraphs 52 to 59 deals with the cash master, and it says that the SASA is an organ of state, that's clear, but for purposes of the impungent contract, so too is cash master. And what Allpay says is that the state can't get away from its obligations by passing it on to another person, and by taking obligations that's part of the state. The NGOs then, in our submission, became organs of state. But even if we are wrong in that submission, Justice, we still say that in terms of the horizontal obligation on them, they still had the duty to care for the mental health care users.
Yes. It's a good proposition. But at the same time, it raises the tension inevitably. The inadequacies of the NGOs are there to see. They're horrific. They're not suited for purpose. So the tension is, as you extend, the reason why you would extend the notion of the state to entities which assume obligations of the state is a healthy one, jurisprudentially very sound. Here, Allpay was doing the paying, and therefore it was an extension of the state. Here, when we do, it depends on how you're going to use that. When we do, the question must be when something is so unstate-like as these NGOs were, whether it's a useful extension of the obligation. But we can debate that a little further. But in law, you are correct. I'm just a little careful in cases where NGOs are so unsuited to be organs of state. Would they still be organs of state?
I would submit that places the blameworthiness of the department in transferring their duties to these unsuitable NGOs. It will just exponentially increase their own blameworthiness.
Yes.
Justice, in paragraph 21, we deal with the rights of mental health care users in our Constitution. We specifically refers to section 10, 11, 12, 27, and 133.
Did I miss that you make no reference to any of the standards under the AU protocols? I seem to remember in one of the submissions there was a reference to protocol on the care of mental health care users.
I did refer to Justice.
You referred it to. Yeah,
I'm not sure whether I took it out again, so it's a little bit late in the day for me to remember. But I will make, if it's not in there.
If it's not in there, you'll make it available to me.
Yes, Justice.
It is quite important that this is not. It's not some standard that hovers somewhere above.
Yes, absolutely.
Somewhere in the global north. In fact, these obligations which have been assumed even by the African Union.
Yes.
And therefore, they are, and we have ratified them. And you made that point last time in your cross-examination.
Yes, Justice.
So I'd like to have reference to that.
I will make sure if it's not in the heads that
Sure.
it is.
Thank
Justice, in paragraph 22, we refer to the National Health Act.
Yes.
And paragraph 23, we refer to the Mental Health Care Act. I'm going to just, those are uncontroverted, so I'm not going to deal with any of that.
Yes.
I will then,
It's a very valuable legal framework. As I said, I'm grateful for that.
thank you, Justice. I will then turn to page 32 of my heads of argument, and at paragraph C2 at the bottom, I refer to the disgraceful disregard of these obligations. Justice, I make reference to a book by Andrew Solomon, Far From the Tree, and it seems to me that this quote is so apt for these proceedings, and if I may, I would read it. Bureaucrats who drew up programs often have never seen a patient, much less treated one. A vacuum of empathy exists in any system that returns people who don't know how to be in a community to communities that may not be prepared to handle them. The lack of support and erratic access to medication often result in rapid deterioration, but family members who attempt to arrest that they are frustrated by the courts. It just seems as an apt quote of what exactly happened in these circumstances.
Yes.
Justice, then in paragraph 25, we deal with the...
I'm not familiar with it. That's a book, is it? Or is it a collection of essays? What is it?
Justice, it's a book on deinstitutionalization and mental illnesses that is around. Thank you. We then say the foremost harm was caused by irrational and irresponsible manner in which firstly the decision was taken. And then the responsibility of this decision must be placed before the door of the MEC of the former MEC of Health and to officials. However, even if this decision was correctly taken, which we of course deny, then the execution of this decision was so reckless that all involved in it are responsible for the harm that's caused. And I will deal with this under 7 headings, and my learned friend has dealt extensively with the facts. The facts are in here. We've tried to put footnotes that Justice does not have to go back to the record to read, but we've quoted them
Yes.
in a manner that will probably, or we hope that would save time. The first issue is that there was no identifiable reason for the closing of Life Esidimeni. And my learned friend have dealt with that completely. If I could just perhaps end this off at paragraph 32 to say there's no reasonable or logical reason for the marathon that's given this far. And it's our submission that the government bore the onus to place honest and correct reasons for this project before the arbitration, as that was within the exclusive knowledge. In the absence of a cogent reason for the marathon project, we submit that you will be able to find that there were no such reasons, other perhaps than that the project was a national political move to harm the interests of life Esidimeni, and that in the process the mental health care users were the ultimate victims. It must also be noted that the MEC, as the policymaker, either was not telling the truth that this project was not driven by her. Alternatively, she recklessly and incompetently neglected her statutory duties as MEC in making sure that the policy and its implementation was lawful and within government policy. And we've dealt with that aspect in cross-examination.
But I surely would have to make credibility findings there,
Yes.
isn't it?
Yes, absolutely, Justice. And we, throughout our heads of argument, we say in no uncertain terms that there are definitely adverse credibility findings to be made of a number of people. Then, secondly, Justice, we say that there were no implementation plan. If we could then move to page 44, Justice. Thirdly, we say that there was a total disregard for human dignity. And we say that our country is founded on human dignity and the achievement of equality and the advancement of human rights and freedom in terms of Section 1 of our Constitution. If I could then move to page 48 of the heads of argument. The fourth point that we make is that the department was non-responsive. And again, we refer to the preamble of our Constitution, which says, "We, the people of South Africa, lay the foundations for a democratic and open society in which government is based on the will of people and every citizen is equally protected by law." And unfortunately, Justice, these patients were not protected, their families were not protected. At paragraph 66, we deal with Section 1D of our Constitution that determines that South Africa is founded on the universal added suffrage and national common voters' roll, regular elections, and a multi-party system of democratic government, and our emphasis lies thereon to ensure accountability, responsiveness, and openness. And once again, it's our submission that that did not happen. We make the submission that there was no consultative process embarked upon. We make the submission that the department was not responsive to the previous tragedy in 2007 when children died. We make the submission in paragraph 69 that they didn't act on their own experts. They didn't act on outside experts. They didn't ignore family members. They ignored marches. And in paragraph 75, we refer to the email sent by Ms. Nkosi to the national minister, and that never reached him. If I could then go to page 77 after that, Justice.
Power or page? You mean?
Paragraph 77. Sorry, Justice.
No problem.
They didn't even listen to the NGOs, because when the staff refused to place more patients per ward, Dr. Malamela and Ms. Jacobus pushed the beds around themselves. And Dr. Malamela lied about her involvement in this exercise. In paragraph 78, we deal with the non-responsiveness to certain NGOs before and after the allocation or the move. Justice, if we can then go to paragraph 85. Dr. Silabano acknowledged in court that he missed the warning signs. However, it's our submission that the department did not miss the warning signs. They refused to listen. The only reason for this is that there was no understanding of our new democratic and constitutional principles and values.
Is it a genuine what? Ignorance? I mean, a genuine lack of understanding?
A general non-caring for constitutional principles, I submit, or for Ubuntu, or for human beings. It's my submission, Justice.
Yeah.
Dr. Silabano also acknowledged that he did not adhere, or the Gauteng Department of Health did not adhere or respond to their own values of being patient-centered, accountable, transparent, and efficient. The department was, even after this tragedy, non-responsive to the Ombuds's recommendations, in that they merely paid lip service to disciplinary hearings. The danger of the department's unconstitutional conduct can be seen in the consequences thereof. The deaths and suffering could have been prevented if the department acted as is expected of a responsible government. Just as then, fifthly, we say that there was no adherence to the rule of law, and we deal in paragraph 90, especially with the fraudulent issues of the operational licenses, which my learned friend have dealt with, and I'm merely going to skip to paragraph 93. In terms of Dr. Grobler's evidence, they've also neglected the legal prescripts of how to discharge mental health care users from life Esidimeni. Just as then, on page 60, we deal with the sixth way in which they disregarded the obligations, in that there was insufficient monitoring even after the death.
Event.
Yes. And mental health care users died of hunger and became emaciated at a time when 82 people were already dead. That was the first time Ms. Jacobus heard about the deaths. It just boggles the mind. If I then can go to the seventh aspect.
What do I do with this preposterous denial of knowledge? You know, we've debated this a little bit with your learned colleagues. It still sits and makes the mind boggle. How could such a big project, so many people, go totally unnoticed by senior officials in the department that was hell-bent on making this happen?
Just as it starts with the MSC not following her statutory duties, it follows through to the department fraudulently issuing licenses, and it lies in incompetence in our submission, and the fact that they were, or that they say they didn't have knowledge, is just not sufficient to get away from responsibility for these. But it lies in our submission in total incompetence, and trying to put something on a subjective foresight, which should have been there if you were competent. If I could then move to the seventh.
You're very kind if you attribute this to incompetence only. Yes, you may proceed.
Thank you, Justice. Then the seventh and the last failing of the department is in the moral, administrative, and competency failures. And we deal with the Gauteng department that has no insufficient regard to the basic values and principles governing public administration as set out in paragraph 195 of the Constitution. Just as I quote in footnote 151 that, and just by reading that we can see that there was total disregard. Part of the moral failing is the department's entering, and my learned friend has dealt with it, but I want to just reiterate it. They enter into a deed of settlement in December 2015, but they did not have any intention to adhere to that agreement. And if one follow the timeline, we can see that. Then when an urgent application is brought, they lie to the court. And the court cannot protect the vulnerable people. Then I deal with, in paragraph 103, with the HOD and the legal departments not heeding the constitutional duty as they should have. And just as this is a failure that we see so often these days, that it's about technical points, it's not about the protection of our Constitution, and it's something that needs to be underlined for state departments to know, and my learned friend has dealt with the Constitution as well. This cannot continue because people died as a result of what happened here. Then another failing is in paragraph 104, when the Drum article appeared. Dr. Malamela's first confrontation with Ms. Njabi was, we don't want to look bad, we don't want to lose our bonuses. That stands out as an immoral attitude to what was said and the photographs in the Drum report. A further failing in our submission is that none of the leaders directly involved wanted to take responsibility. And it's our respectful submission that this is disjointed and fragmented roles that this procured, and it's either dishonest or this total ineffective leadership. We deal with the fact that the officials was grossly incompetent. We deal with that in the footnotes. And just as what stands out is Dr. Selebane, that sees himself as blameless in this strategy. He endeavors not to give any evidence by applying I think I've misread myself now, but he didn't want to come and give evidence. He tried even to go to the High Court to prevent him from giving evidence. That's not what we expect of a responsible leader. The Umbud complained about the type of collective obedience. I think that the Minister of Health have put stop to that, showing that that can never be part of democratic processes. We deal with the lack of understanding of statutory and constitutional duties and officials complying with unlawful instructions. And then the current HOD told an untruth to this court by saying that the department did not make recommendations as to what sanctions to the various disciplinary hearings. That was also not true. And to top this all up, even after this process, the officials that were involved in the Marathon project received performance bonuses. It just flies in the face of the value of people's lives. My learned friend have referred to the professional misconduct, and I'm not going to deal with that. I deal in paragraph C3 with the effect on surviving mental health care users and their families, and I quote Ms. Nompilo Nkosi that said, "Our loved ones are cold in strange places," and that sums up much how they experienced what was happening. We've dealt with the number of mental health care users that are still missing, and I've dealt with the traumatization, that the family members were traumatized. Justice, we have supplemented just to put in more of the stories of the family, and I'm not going to read through all of that. That is before the court. I have to, however, deal with two separate incidences and 3 family members. If I could go to paragraph 142. This is the evidence in LR 147 of Ms. Sophie Kansa about her father, Guy Daniel Kansa, that was a patient. He's still missing. And it's important to know that he's not on the list. Judges, and then I'm duty-bound to refer you to page 148 and just deal with the evidence there and to lift out, that's the evidence of Mr. Mordechai Mahambu. His brother was part of this process. However, he passed away in 18 August 2017. It's important to just underline this because ordinarily in litigation where a person dies, his estate can only follow up if he dies after the close of pleadings. And close of pleadings, if you use the terms of agreement as close of pleadings, that would be on the 8th of September. So he had died before the close of pleadings in this respect. So he might have to lose his claim. But I submit that his family would not lose their claim because he didn't die as part of the project. He died after the project, and they went through this project, and the uncle bought things for him and were traumatized by what has happened here.
But he was moved to Tsepong in May 2016.
Yes, Justice.
But why would he be excluded on account of what? His date of death?
Yes, only on his date of death because it's before close of pleadings. I had to bring this to the attention of you, yes. Justice. I'm duty-bound and to my yes. learned friend. There's another such a person, and that's on page 4660 of the record. That is in respect of Fakazile Dibechu. Her aunt died, also part of this process, but the aunt died on 8 September 2017. So that was on the same date as the terms of reference. I would submit that her claim would fall into her estate then. If I could then move to C4.
Well, that's quite tricky. Assuming there was a distinction between survivors and claimants in respect of the deceased, what amount would be due to them? Which category of amount?
To the deceased or to the family? Just
well, the deceased is not here. I'm saying if we were to make a distinction on account of the date of demise, the claim of the family, so the claim of the estate, would that be entitled to whatever amount might be granted in respect of
the survivors,
or
I would submit,
or should it be in respect of families whose loved ones have died?
Justice, we will get to that in terms of our relief that we seek. We try to put the family members' trauma on a different footing as the survivors, because we submit that there is a difference. So in terms of these mental health care users that passed away, I submit that their relief will be on the same footing as other survivors, and their families' relief will be on the same footing as other families' relief. And I will deal with that
Okay.
in due course.
Yeah, let's get to that then.
Justice, then we deal just with the losses of people not party to the proceedings, and it's just an idea to show how irresponsible and irrational the plan was. There's more than 700 professional persons that lost their jobs, despite many requests from yourself, Justice, and from us for the precise number that hasn't been given. There's no more training. The training was stopped. The NGOs were told to renovate buildings without a plan. The buildings wasn't allowed. They lost money. The person that was tasked with supplying linen apparently lost his house. And all this just showed to the unintended consequences, and it just shows to no plan at all by an uncaring department. Justice, then I deal with wrongfulness, or we deal with wrongfulness under D. If I could go to paragraph.
Why do you do that?
Justice, the reason we deal with it is...
Terms of reference concede that outright.
With respect, Justice, in our reading of the terms of reference, they only concede to negligence. And we submit that their conduct exceeds negligence. Perhaps if I can deal with it...
No, but wrongfulness here, of course, would mean unlawfulness, wouldn't it? Negligence is one element, unlawfulness another.
Yes, but what...
You already said unlawful or wrongful, negligence...
Yes, this goes to it goes to intent, but we've dealt with it under this to show that even though they've accepted that they have gone astray, the whole project, we want to just deal with in our understanding on negligence. So what we say is in paragraph 161 is that negligence is proven when the conduct complained about falls short of the standard of the reasonable person. Justice, you know this, and I'm sorry, I'm not lecturing to you. I'm just trying to get to the next point. The state says, yes, we were negligent, but we argue that they were reckless. And instead of then working with an objective assessment of their conduct against that of the reasonable person, we argue that we can work on a subjective assessment on their own conduct and the harm that they've caused. And that in itself has an influence in our submission on the solace that this court will give, because it goes without saying that intentional harm hurts you more than negligent harm. And it's the difference between, in criminal law, culpable homicide and murder, and the sentences that comes in there. Because as soon as a person, even if it's culpa lata or even dolus eventualis, the blameworthiness of the perpetrator comes into play, and that makes any award that this court will make will then be higher.
You see, the Ombuds finds recklessness.
Yes.
And the state admits the contents of the Ombuds report. In the agreement, they admit negligence. I hear the point, and it may well be... I'm sorry, Aviwe, would you get me a cord, please, to plug in my laptop from which I read? So, I hear the argument. I'm saying on all versions, I think both negligence and recklessness have been admitted.
Justice, I'm not going to argue with them. They say they accept the report.
What is individual perpetrators, and I call them that advisedly, were careful to try and scrum away from dolus eventualis if you were to be tried criminally. And I know you may very well obliquely be going there. But for delictual liability, I think we have more than enough on our plate.
Justice, I'm
For
not
criminal
going...
liability, I think, I don't have to express my view on that, but it is something that another judge will do so. If you know enough to have reason to believe that a certain consequence will eventuate, and in truth and in fact it does eventuate, the law has always been quite uncomplicated.
Justice.
You have reconciled yourself with the consequences.
Yes.
Shooting into a crowded little toilet, and the consequences ensue, the law will impute.
Absolutely, Justice. Justice, I've dealt with those issues up until paragraph 168
Yes.
with the facts, and I'm not going to repeat that.
I've seen them, and they'll be helpful for the NPA, I think.
Justice, then we say that the department has very, very close to COCOTUS, the matter there, tried to say, but we were exercising a right, but they were actually abusing a right. That's just as general background. I'm not going to do anything of that. In paragraph 170, we say that the harm-causing conduct goes further than merely abusive motive. We deal with recklessness, and then with this as background, if we could then deal with the relief sought.
Yes.
Justice, in paragraph 172, we say, insofar as this arbitration was to find the true reason or reasons behind the cancellation of the life Esidimeni contract, this process has failed. Nevertheless, we submit that it has exposed the Gauteng Department of Health's reason for the Marathon project and the resultant tragedy as false and malicious. So in that aspect, it did not fail. And to this end, the evidence of especially Ms. Mshlangu, Dr. Malamela, and Dr. Selebana has been shown as false beyond a shadow of a doubt. Insofar as...
But hell, you know, Advocate Klaus, one can't resist saying and asking again and again and again, what were they doing? The reasons are false. They are not the real reasons. We were told by very senior power wielders in the province. And the question pops up, what were the real reasons? Are you any wiser? Of course not.
Justice, it's our submission, as we do in our heads of argument, is that there was an ulterior motive. We wouldn't know what it was. But it's for the state, with their inside knowledge, to tell this arbitration what it was. In the absence of that, it just shows to the recklessness. That's our submission.
And the whole state machinery, right up to the minister, can't tell us what have they discovered, discerned from then to now.
Yes.
What was it?
Justice, in paragraph 173, we say, insofar as this process was aimed to remind the state about the statutory and constitutional obligations to mental health care users, we have endeavoured to highlight that through cross-examination, and we hope that with respect that your award will remind the state as a whole about the rule of law and constitutional principles, and forcing the government to put functioning systems and structures into place to ensure the well-being of mental health care users. Insofar as this process was aimed at forcing the government to put in proper functioning, we have the evidence that there was a staff cleansing at the department, that there were new information structures and new reporting lines have been created, and we hope that that would make a difference. we've dealt with this before in argument, but I just want to reiterate again. It's necessary that State departments need to be reminded, most urgently, that frivolous and untruthful and technical points does not belong in human rights litigation. We've shown, with respect beyond a shadow of a doubt, that the department was dishonest in their opposition in Takalani, the contempt case. We've shown the Sia Bedinga matter that is before the court in LR 169. What is particularly heartbreaking of the Sia Bedinga case is that they've asked that the curator ad litem be appointed. We have the sister of Yaku Sols that's saying in the founding papers, please appoint a curator ad litem. These are the photographs. This is how it looks. The department comes back and say, no, that's totally untruthful. She then makes, in reply, again says, I'm afraid my brother's going to die. The photographs are true. And within a very short while thereafter, her brother dies. And the frivolous point taken by the state legal representation is that the Rule 57 hasn't been followed. There wasn't a psychiatrist, which is, with respect, it just flies in the face of human rights litigation. And that needs to be underlined with respect, Justice, in human rights positions. That cannot happen anymore. And for this reason, and it can also fall under constitutional damages, we ask that the state would make a contribution to a charity of the attorney and own client costs in both of those two matters. And the reason we ask for this is that there must be some thought that the state can't get away with untruths and taking technical points, and then know that if those points had not been taken, we might not have had the deaths that we now have. Justice, then it is our hope that if the court makes such an order, that the consequences of such unethical and indefensible conduct will be discouraged. Insofar as future governments and future generations should be reminded, we've made the suggestion in paragraph 178 that something like at Freedom Park or the Steve Biko Museum in King Williamstown, that something akin to that should take place, because there's a lot of documentary evidence, there's a lot of photographs, there's a lot of things that can be looked at, and we submit that it would be a good idea if future generations had that opportunity. Insofar as a proper acknowledgement and apologies should take...
So on that, I would require the province to do that. What else do I fix? And who makes sure it happens?
Justice, again, this is not a supervisory role that you would want to assume after these proceedings. Could we come back and reply to...
And think about that, about the details.
Yes.
I'm just in that mood as a judge. I know already the responsibility would be with me to fashion an order. And orders don't sound in generalities.
Absolutely, Justice.
They never do. So I've done that for many, many years. You have to go down and write out an order that is capable of compliance. Otherwise, it's no order.
Absolutely, Justice. Justice, and then as far as acknowledgement and apologies should take place, that has run its course. Some apologies were more sincere than others. However, it's our submission that the process of stigmatization is continuing in the uncaring attitude of some officials that led to this arbitration. If I can then move to the compensation for survivors and their families. And the starting point is...
Shouldn't there be a crafted public apology at the end of all of this, written and given some level of publicity? Or should it be sufficient, written and crafted by the head of the province or whoever, at the end of all this, to say never and never again? And an apology that would be to everybody else who has been dragged through all of this. Or is the apology given here sufficient?
Justice, we haven't taken specifically instructions on that, but such an apology can be dusted off in 3 years' time when the Life Esidimeni contract is again willy-nilly cancelled. That would not be a fruitless or fruitless exercise in our submission, or my submission. In our submission.
Yeah, free of all the emotions of a hearing or anything, yes. Public pledge of sorts and an apology. Some that a never, never again.
Yes.
Kind of position.
The previous never, never again is shown not to have worked, Justice.
Yes, I know. Mr. Mandela did promise us never, never again when we were sworn in for the first time. But we'll have to still continue trying.
Yes, Justice. Justice, at paragraph 180, I just deal with some of the law dealing with the inuria and actio legis aquilia, and I'm not going to repeat that. Perhaps at paragraph 183, I can just refer to Justice Strathworth in Hersman versus Shapiro, where he said monetary damages have been suffered. It's necessary for a court to assess the amount and make the best use of it can on the evidence before it. There are cases where the assessment of a court is little more than an estimate. But even so, if it's certain that pecuniary damages have been suffered, the court is bound to award damages. And I submit that there can't be anything wrong with that. We then deal with the counselling aspect. Just as we refer to the court case, the Premier versus Western Cape versus Kivitz at paragraph 11, that says it's impermissible for the state to provide future medical like counselling, unless without paying a monetary equivalent in the absence of legislative empowerment or an agreement. Insofar as we are concerned, there are no such an agreement. We therefore ask that, in respect of the families that we represent, that a monetary amount be given, and we suggested that that amount should be 20,000 rand. In our statement of claim, we started off by saying 50,000 rand, but we have now referred the court to the SADC website to show that it might not be sufficient.
And 20 would provide how many sessions and to how many people? 20
would be more than 2 people for more than 8 sessions. So that should be sufficient in our submission.
2 times 8, or 8 for 2?
8 sessions for 2 people. Just more than that, Justice.
Thank you.
As to the clothing and travelling, we submit that an amount of 5,000 rand for specific damages for the replacement of clothing, and 1,000 rand in respect of cost for the location of the mental health care users. In respect of shock, pain and suffering, Justice, again, we have set out the law. We've set out what was suffered in our submission, the suffering was foreseeable and was in fact foresaw by the department. We submit that but for the deaths of the mental health care users, the families that we represent suffered a trauma akin to that, and that was the evidence as well of Ms. Trotter. We refer in paragraph 199 to emotional shock aspects, and in the Mart matter, a child was killed by police, and in 2017 terms, that's 249,000 rand that was awarded. In Minister of Safety and Security versus Raymond Augustine, there were two claimants, or there were four claimants actually, but the court awarded, and this is a 2017 case, 200,000 and 250,000. In the Lat matter, again, a child was killed. And there were two plaintiffs, and in 2017 value, they were awarded 138 and 165,000 rand. In the Walters matter, the husband was arrested by the police and he committed suicide in police custody, and in 2017 terms that would damages or general damage was awarded in the amount of 243,000. In the
light of the tender by the state, what do you make of that, given the numbers that you're setting out here?
Justice, I can only speak to, I don't think that the state has tendered us the same amount that it's awarded to, agreed on by the two, the other claimant parties. But in terms of what is set out here, if I can answer perhaps in two ways, and I will come back to the families' general damages, but we don't only represent families. We also represent mental health care users, and as set out, or as we will show now, they've suffered more than their family members. So in terms of only the family members, if that is offered, then of course, and it lies in the hands of the court or the arbitrator to award that. But we want to, with respect, show also in the Kritzinger matter where the children died in a motor vehicle accident, and the court awarded damages in the amount of 231,000 rand. All of these acts were negligent acts. They were once-off acts, and they were unlike the Marathon project. These were prolonged trauma to the family members that could not be heard. They tried to be heard. They tried to make sure the family members died. That gave up their lives or their working lives just to support. And I would therefore submit that a fair general damages for family members would be 300,000 rand. In respect of general damages to survivors, we submit that it's on a completely different footing. And we could find no authority on quantum of patients that died of or that suffered hunger, thirst, and cold as patients in a hospital. And that must be an indication in our submission that it's unheard of in any civil society or civil place. We submit that the lack of food and water has been dealt with in evidence, and the trauma of this intense suffering outweighs, in our opinion, the trauma experienced by any family member. We refer the court in paragraph 203 to the matter of Smith versus the MSc for health. It's a 2016 matter. The plaintiff had just had an operation. She woke up in the recovery ward and she asked for water to drink, and instead of water they gave her formalin to drink. The court awarded her damages in 2017 terms of 361,000 rand. In Eastis versus Metro Rail, the plaintiff was injured when a trail derailed after a collision. He was awarded, in terms of 2017 values, 590,000 rand. In the Gibson versus Berkovich matter, the doctor negligently placed undiluted acid in the vagina of a 20-year-old woman. He should have used diluted acid. The court awarded, in terms of 2017, general damages of 247,000. Now, having regard to these severe abuses, the suffering of the mental health care users was akin to torture. And it was much more than the once-off suffering or negligence conduct of what happened in hospital.
Well, yeah, the argument is quite, sometimes leaves me a little not understanding. You see, I don't understand the election you've made. Approaching this as a delictual claim only.
Now, with respect, Justice, we're still getting to the constitutional part. I'm only on the delictual part of that claim now.
Yes, because the youth, you see, all the factors you are raising undermine one or other constitutional entitlement and protection. And the idea that there are common law delictual damages on the one side and constitutional damages on the another is one around which I have to get my arms,
yes,
as you've heard me talk earlier. Formulating one's claim in delictual terms would amount to no more than using the common law as a vessel, as a container. And where the common law can do the job on its own fully, that is fine. Where it cannot, because an overarching violations of the Constitution, then we have to think hard and long.
yes.
Where do we draw the line? All I'm saying is that I find difficulty in drawing the line.
Justice, what you've now stated as the law, we've dealt with that in our heads of argument, but we would want to make a suggestion very soon. If I might just finish off on the delictual part of
Yes.
where we're going. Justice, we say more appropriate than these awards that we've now referred to would be in paragraph 207, M versus the Minister of Safety and Security, where a woman was arrested unlawfully and then repeatedly raped in the police cells by the cell commander. And the 2017 value of her general damages was 472,000 rand. And in DW versus Minister of Police, the claimant was raped by a rapist on bail, and the court awarded general damages in the amount of 750,000 rand and contumelia in the amount of 350. Now, these two cases are very seriously, and they would no doubtly have a long-term effect on the victim. But we would like to argue that the harm-causing conduct for the mental health care users was a more prolonged misconduct. And we would therefore suggest that for general damages, an amount of 750,000 rand for each mental health care user would be appropriate in respect of general damages. But Justice, as you've set out, and we've said in with reference to the rail commuters action, sometimes these general damages are not sufficient to vindicate in delict what should be vindicated in constitutional damages. Now, with respect, Justice, you have made some transition about constitutional damages since 2006. And in 2006, it's our respectful submission that you said if this can do the common law remedies can do the trick, there's no reason to move away from them. But then in 25th November 2010, in the Law Society versus Others versus Minister of Transport, you opened the door slightly that there might be constitutional damages. And what we've listened intensely to what you have stated so far, Justice, and we hope to show that constitutional damages in a case like this is important to consider. And we don't want to preempt what your decision is going to be, but we would submit that general damages is not sufficient in this matter. You've seen the atrocious evidence that we've heard, and it's important that there must not only be a punitive, that there must be a punitive impact on what has happened. And I submit that constitutional damages could do so. Justice, if we might, and then we'll end off by this, if I could refer you to an article. It was written in the Acta Juridica in 2015, and I know that you must have seen it before because you've also written an article in that document. But this was written by Alistair Price on the occasion of Chief Justice Lange's death. And the idea of this article was to deal with state liability and accountability. And I submit that the author of this makes a compelling argument for constitutional damages. And if I might just refer you to some aspects of this article, on page 315, the author says, what is accountability? And then he says, first, to hold people accountable or to account means requiring them to explain or to justify their actions. Accountable government, for instance, have a duty to explain and justify their decisions, actions, and laws to citizens. Now, this is what this arbitration tried to do, is to hold the government accountable, to ask them to come and explain. Now, he deals with the ways to do that, but I'm not going to refer you to that in itself. If I might refer you on page 320, and that this is still accountability, the second paragraph says, of some importance here is the distinction of degree drawn by the Constitutional Court between the general characters of public litigation and remedy and private litigation and remedy. The Court has stated that, generally speaking, whereas private litigation tends to concern with the determination of a dispute between individuals, relief is specific and often retrospective, and non-parties are seldom directly affected. Public litigation tends to deal with more diffuse and amorphous harm, to be more forward-looking in its outlook, and to affect directly a wider range of people. And then he refers to the rail commuters case, which, with respect to you, are well aware of. And he says, anonymous court remarked that private law damages claims are not always the most appropriate method to enforce. And then he goes on to deal with state liability. And if I could also read to you that first paragraph. It says, without doubt then, imposing liability on a state to pay a monetary sum or damages to a victim of wrongdoing is a well-recognized and appropriate legal means of securing accountability, which rightly coexist alongside the other legal and political accountability mechanism summarized above. It is, if it chooses to resist such a claim, that's the government, the state will have to defend and thereby account for its challenged conduct. If it admits liability or is held liable, the state is held responsible. Now, then he deals with the ways in which the state can be held responsible, and that's on page 321. It says it's either a delict or a statutory compensatory scheme, or in terms of the promotions or the PIA Act. And finally, towards the end of that paragraph, if I can leave, finally, public functionaries may be held to pay constitutional damages for breaching a requirement imposed by the Constitution. That is, monetary award may on occasion constitute appropriate relief and a just and equitable order in terms of Section 38 of the Constitution. Now, what he says is that the public functionaries can be bound, as you've also said with respect, Justice, either by the law of delict or by one or other of the other three mechanisms. And then he asked the question on page 322, how then does the South African law manage the relationship between these various potentially overlapping branches of law? And with respect, he answers them by dealing with them separately. But I would want to take the court to page 324 towards the bottom third of the paragraph.
Okay. I'm relieved. I thought they were going to take me to 323. Steenkamp. But we're not going to go there. Let's go.
Justice says, in the third place, consider the relationship between constitutional damages and delict. And then just a little bit off. Our courts, moreover, must promote the spirit and values of the Bill of Rights when developing the common law of delict. So he says one way of dealing with this is to develop the delict. But then he says, in many cases, the common law will be broad enough to provide the relief, and that would be appropriate relief. But that depends on the circumstances of each case. And then he refers to Forsey. And of course, our submission is that in these circumstances, it's not enough. On page 326, in the middle of the page, he says, given the willingness of our courts to stretch the state's delictual liability in various ways, there has been little need to rely on the subsidiary remedy of the constitutional damages, which consequently remains rather underdeveloped in South African law compared to certain other systems. So he says courts try to put more into the common law remedy, and he doesn't criticize, but he said more can be done. And if I can then, page 327, he refers to the hybridization of delict as referred to by Justice Sachs in the Constitution. And that's, in effect, what happens. And then he deals with accountability and a new public law delict. And that's where I would like to take the court to. In page 329, in the top part, it says, in my view, the Constitutional Court has led a hitherto unnoticed shift away from the Duivenboden approach of presumed delictual liability for public law wrongs, adopting a more flexible case-by-case assessment of whether recognizing a novel delictual duty and thereby extending liability will or will not promote accountability. So if the court decides whether to extend the general damages, the delictual, or the constitutional damages, one of the questions I respectfully submit should be uppermost is, should there be accountability? And would this promote accountability? If I could then just very briefly, just as I'm very nearly finished, if I could go to page 331, under Roman 5, he says, when and on what basis is it appropriate to hold public functionaries liable to pay monetary sum to individual victims of wrongdoing? And at the bottom of that phrase, when should we direct public funds to compensate individual victims, and when should such funds rather be spent on improving fallible state services that's failing in the first place for the general good of all? So that's one of the issues that the court will grapple with. Of course, we're not saying there's not enough money, but we say that that is a consideration that the court will take into consideration. Then at page 333, he says, given the state's distinctive constitutional duties, a distinctive public law of state liability may be needed, and was explained in the previous section that he referred to, has in fact started to emerge as the law of delict. And then he refers to Du Bois and Bonsaire, that the traditional delictual model of vicarious liability is not well equipped to deal with all the state's own duties as opposed to that of his employers. And that's part of the question that this court has asked. In how far is the individual officials here, must they be held accountable? But if the court sees the bigger picture with respect of the state that's failed, then there should be a direct responsibility. And of course, and I'm not going to read through all of it now, but of course that is the whole problem of whether there's a direct liability or whether it's a vicarious liability. And that's something with which the Constitutional Court has given some thought to.
It's an interesting article. Thank you for the reference.
Justice, and then he just says maybe at some stage he says you need to decide whether it's public or private law, and you need to decide what you want to reach with this. And it's not necessary to extend the common law principles.
Hence my question, why the split? I know all of you have done that in varying ways to try and struggle If you don't catch it on the one end, you catch it on the other.
Justice, I think the reason why we've done it is because of the authority that say you must go to where you can find your relief. But what this article says, it's not necessary to go that route. You can go directly, as she's also remarked to my learned friend. So that is where we're going. I would
you see, historically, Advocate Krause, the problem has always been there, and I alluded to it. In the early years, if you remember the judgment written by Kentridge A.J. in Zuma, and this under the interim constitution. And the court then was, you always start with the common law. When it goes limping, then you go to constitutional law. Came young Turk judges later and said, we don't know what these older judges were saying. And I may or may not have been one of the young Turks. And you go and look at cases like that came later, Metro Rail. And the big question there was somebody who got killed in a train that was not properly policed. And later another Metro Rail case where somebody was thrown out of a train.
Yes.
In both cases, it was totally premised on failure of the state to accomplish and fulfill its obligations under statute and the Constitution.
Yes.
And the question was, do you couch these in ordinary, usual, delictual subheads that we all have learned? It's a commission or omission, which is unlawful, which is perpetrated wrongfully and recklessly and or negligently, and as a result, harm has ensued. And then you go to the traditional way of doing it, look at the causation, harm has ensued, and then you grant damages. It's a traditional claim. If somebody were to come to court and suffers enormous harm, being precluded from accessing education, or accessing healthcare, or housing, that formula will not.
It won't work.
It won't work. It's a commonsensical thing. It won't work. So then the question becomes, whether, in fact, there is no remedy in the face of Section 38, read together with Section 172, 1B, and read together with the total import of the Constitution, Section 7. The obligations set out in this Constitution shall be fulfilled, are binding and shall be fulfilled. So you can't go down that route where you non-suit somebody because they have not claimed it's an act or an omission committed by a servant of the state, done recklessly and negligently. Have I established vicarious liability? Have I established causation as required in normal delictual claims? And to go to the boot, you must still show that in fact damages ensued, because you've got to place the claimant in the same position she would have been but for the delict.
Yes.
And after that exercise, you could send somebody packing. You haven't shown me that you lost a penny. Sorry, bye-bye. That was the one approach under the common law. Constitutional imperatives impose all of this debate you see in this article, you see in Steenkamp, you see in Metro Rail, in Mulder Club, and we can go on and on, Indikoko. Where's the intersection between the common law and constitutional imperatives? And that's really where we are, isn't it? So here, when we say the pain and suffering and the shock reside cruel and inhuman treatment, or it resides in the shock, delictual shock claim. We can debate that, but in the end,
it's a constitutional issue.
They're constitutional issues.
But it goes further than just the it goes to the breach of statute duties that's part of the rule of law as well. So,
yes.
And our submission is, although we've thrown it over the common law remedies for general damages and for specific damages. What we're saying is that just doesn't go far enough in respect.
I hear the argument, yes, I hear it. And you may want to start there, as you have done. And lawyers are very conservative. They start from the known to the unknown.
Yes.
And they tend to go slowly towards the brave new world. But in fact, if you have egregious, the Constitution requires accountability, you cannot ordinarily hold it delictually. It's not easy. People fraudulently write out licenses.
Yes.
How do you hold anybody accountable delictually?
No, there's no delictual accountability there, Justice.
Yes.
That's why we're saying the common law just doesn't go far enough. But in terms of the common law, there was some intersection in that our clients have suffered general damages.
I hear the argument.
Good pleases. We therefore submit, and we've submitted that there's a direct constitutional damages for mental health care users. And again, we use the term mental health care users as per the Act, which includes the family and the mental health care users,
Yes.
and that they should be awarded damages, constitutional damages.
And what number do you put to constitutional damages?
We've put R1 million to constitutional damages. We say if the court is not amenable to that, the court should then develop the common law to include R1 million to
and
that.
750 would be
That would be
general damages,
general damages
for
yes.
survivors.
For survivors, and then the 300 for the families.
For the families, yes.
In the event that my learned friend, as I no doubt he will argue and say we haven't proven that, then of course that falls under constitutional damages. Justice, and then if I could just lastly deal with the aspect of costs. May I still continue, Justice?
Yes, please continue.
Justice, the President Meyer, she wasn't president then, said in the Legal Aid South Africa versus Magidiwana matter, that's the Marikana matter, and I quote, she says, in respect of the issue of cost, she says, what happened at Marikana is extremely rare, and hopefully a tragedy of this kind will never happen again. And we must say a wish has shown not to be true. We therefore submit that our participation here as survivors and family has not been frivolous, hasn't been vexatious, and it raised a number of factual and constitutional issues in which we hope we will be successful, and that we are therefore entitled to party and party costs in these proceedings. Usually, party and party cost does not include disbursements for travel and accommodation, but we have shown that the disbursements for travel and accommodation was close to 127,000 Rand. We've put that in paragraph 223.
Yes.
In terms of the Legal Aid Act, in terms of Section 20, the costs are ceded to Legal Aid South Africa. In terms of the manual of 2017, paragraph 8.1.16c places a duty upon council to recover costs, and the regulations...
You don't have to apologize beyond this.
Justice, I just want to say that in terms of the regulations 26 of the 27 regulations after the Marikana matter and the Constitutional Court case, it says that legal aid will only be provided in commissions of inquiry where the establishing authority give funds. The establishing authority didn't give funds here, and this is not this is an arbitration.
Yes.
Justice, then in our conclusion, we just deal with...
The only question is whether you're entitled to recover costs. And being an entity, give it birth by statute. And if the answer is yes, and the statutory provision for it, that's the end of the inquiry.
Thank you, Justice. Justice, then, and just in conclusion, the Marathon Project was rightly labelled by the Minister of Health as a period of darkness and a moment of madness. We have dealt with what we see as darkness and madness. We've dealt with the harm that's caused, and we have dealt with the payments that we want in respect, or that we seek in respect of redress. We have egg on our faces, Justice, in so far as between paragraph 227.6 and 227.7, we have neglected to insert the constitutional damages. That was merely an oversight, and it wasn't a Freudian slip. If we could include that there, Justice, and then we ask for the party and party costs, including cost of counsel.
And that would come as 22.7A or something.
Yes.
That is the 1 million claim for constitutional damage.
That is so, Justice. Justice, those are our submissions.
Thank you for very full heads and with ample references. Much appreciated. Advocate Groenewald, we're going to take a comfort break. You know, let me tell you a little story, having lived longer than you. When I was working at the IEC, just before the elections, before the 1994 elections, some people were coming to register their name in a political party. And they were haggling backwards and forwards during the registration process. And one of them said, whatever you do, your party must have A in its first component of the name. So you must be African something, or athletic something, or Africana something, because then you have the advantage of precedents. If you use A for your party, just keep that in mind one day if you want to open up the party. Because the list is always alphabetical on the IEC ballot. And many people will see your name first before they go down the long list. You might have an advantage. So next time, make sure you're the first counsel, not the last.
No, thank you, Justice. I accept it.
Advice for nothing, thank you. We are adjourned for 15 minutes and we'll continue.
just in short with it. The first issue is the proverbial missing piece of the puzzle. And both of my colleagues have referred to that. But I do submit that that reason, or the fact that we do not know why was this life Esidimeni contract cancelled? Why was it done in so haphazard manner? Why didn't they follow the initial policy or the plan? That is an obstacle in respect of finding closure for the families, which is one of the main objects of these arbitration or this arbitration proceedings. And it most certainly must be worked into or taken into account when considering what is just and equitable compensation. Now, the further issue that we've identified, Justice, is the unlawful and the unethical conduct of government employees during this project. And we've highlighted a number of those, and my colleagues have also referred to that. The main issue is we don't even know how these NGOs were identified. Mrs. Jacobus came here and she testified that they didn't even submit applications. We know that these NGOs was not qualified or experienced enough to look after these individuals. The licensing process, we've gone at lengths of exposing the unlawful conduct that went apart with that. And once again, Mrs. Jacobus came and she said to us, I admit it was unlawful. Dr. Manamela came and testified and said, no, everything was done according to the law, according to the prescripts. However, Mrs. Jacobus testified and she admitted that it was unlawful. Those licenses was issued simply based on a budget letter. A budget letter. That was all. Now, Justice, so also the transfer of the mental health care users. Having regard to the fact that we represent the family members of 4 mental health care users who were patients at CCRC. In terms of the Ombuds report, those individuals were sacrificed to other NGOs to make place for life Esidimeni patients. Now we know at least, or according to the record, patients that were admitted to Siabadinga, it's unclear and they weren't assessed. There was no determination as to what was their mental and physical conditions. We know that there wasn't any medication. We know that there was a problem with the food. We know that some organizations had to assist to get the food. Then we also know that when Siabadinga was closed down, a lot of the family members didn't even know about it. We also know that when those patients were transferred back to CCRC, they were never formally admitted as patients. Now, Justice during the evidence of Mrs. de Villiers pointed out that that was perhaps one of the reasons that they didn't admit him at hospital at Mamelodi at one point in time when he was ill. So there was just a total disregard of rules and standards and norms. We also know that Mrs. Monaka considered that at least 38 mental health care users were not assessed by clinicians who were placed at anchor, all under gruesome cross-examination where we established those facts. The competence to care for the mental health care users, Justice, I think the evidence and the record and the transcript speaks for itself. We've sat here, we've listened to it. We know that these facilities, and the Ombudsman has confirmed it, were not fit to look after these mental health care users. Now, the circumstances, Justice, I've highlighted the circumstances regarding the deaths of Jaco Stolz, Thabo Monyane, Khotsu Mpofu, and then Jabulani Mhlongo. These are tragic stories, Justice. These are tragic stories that no individual wants to hear. They are the stories of Mrs. de Villiers, who pleaded that her brother be admitted, who sat here and listened, only here realized what was the exact extent of his medical condition. He was vomiting a brownish substance for 4 weeks, which we later learn is caused due to internal bleeding. He lost 14 kilograms in 2 weeks' time. And at the end of the day, it was she who had to admit him, or to ensure that he was admitted at Mamelodi. The stories of Thabo Monyane, once again a mother phoned, and a mother said, well, your son is ill. And she asked, since when? And the nurse couldn't tell her, since when is his son ill? When she came and picks him up at the hospital, 2 days thereafter at CCRC, and she admits him to hospital, 2 days thereafter, he passed away. Khotsu Mpofu, his family up until today doesn't know what was the exact cause of his death. There's just no answers, no information. Jabulani Mhlongo, we know now, has had an epileptic seizure from at 1:45 in the afternoon. 9 o'clock that evening, he wasn't yet admitted to hospital. The doctors didn't want to admit him. This tragedy has befallen them not once but twice, or the system has failed them not once but twice. The family was failed by the Gauteng Department of Health in respect of the project, as well as in respect of our hospitals, who didn't want to admit him. Just as in respect of the failure of government to intervene, there's a lot of individuals that say that they didn't know. They didn't know. But the long and the short is, the facts were in front of them. And especially in respect of the Premier, we know what the evidence said. The evidence was quite clear. November of 2014, the Department of Health tabled their budget, and they said they want to reduce 20% of the bed. In November of 2015, the Premier is informed that they're going to cancel, they had already cancelled the contract with Life Esidimeni. Now, this is a department who has been under administration just the previous year, but no questions are asked, but where are those patients going? What is the sudden change of heart? Last year you told us you're going to reduce bed by 20%. Now suddenly we hear that you've cancelled the contract. But the evidence shows us that those questions are not asked. There was no due diligence. There was no proper care. I'll try and speak a bit softer, judges. I think we're trying to compete here. Just as I've indicated that subsequent to this tragedy, what are we faced with? You have referred to the scales of justice numerous times. Now, at the one hand, we have 144 individuals that have died, thousands who have suffered. And at the other end, we have 3 individuals, key role players, who have simply resigned. And we have 6 officials who were issued with final written warnings. And we have the head of the Mental Health Board who was found not guilty. Now, where's the accountability? Where's the accountability? We know also that up to today, no formal action, criminal action, has been taken against any of the state officials. That is still pending. Justice, I don't know if I should push through or...
Can you speak any louder? Any louder than that?
Justice, I'm going to be 20 minutes, so if we can do it tomorrow morning and I can wrap it up.
Yes, I think so.
Thank you.
It is a lot of rain. I think it may be, hi there, it may be prudent for us to start tomorrow at 9 a.m. Shall we resume tomorrow at 9 a.m.? Will that be suitable to all counsel? 9 a.m. tomorrow? Start. In other words, we'll start deliberations at 9 and allow Advocate Groenewald to have a proper address. It's a lot of rain. We should be sending some of it up to the Cape or down to the Cape, but I think it's down to the Cape. But it's a lot of rain. And I've given some amusement to some of the camera people here. But we're going to adjourn now until tomorrow morning at 9 a.m. Thank you.